And so moving forward, today we have a presentation. Presentation is going to be given by Nora Aliyami, is an attorney, and I'm going to go over her bio briefly, and she's going to walk us through some helpful information. Um, she's going to give us some information that's going to, kind of empower us, so to speak. And so I'm going to read her bio. I'm going to get right into it. I want to maximize our time. She has some great things to share with us, and so I don't want to hinder this process. I do want to uplift that as that we're all fathers here. I know that we all have different journeys. I know some of us are having different struggles. So I just want to say that even in the midst of that, that we're all fathers. Everybody's journey is a little different. So I just want to create space for that journey being different. I think it's important that we have ground rules in the terms of that. That when it is time for folks to talk, that we're open in the sense of two ideas can exist at the same time. Be open to hearing new thoughts. One of the things I think is always important is just being mindful of etiquette. That if you aren't talking, put yourself on mute. Without any further ado, I do want to recognize our presenter, Miss Aliyami, and she's a native to the Bay Area. Grew up in Contra Costa County. She earned her bachelor's degree from the University of Florida, University of Miami, Florida, which is she's a lifelong hurricane. Okay. Nora maintains a deep commitment to eradicating both race and gender-based oppressions. And she really wanted me to highlight this piece here, that she's the co-founder of the Family Law Advocates Group, which is a group of 4 women of color under 40, and the main focus is family law and domestic violence. With no further ado, I want to give the floor to our presenter, Miss Nora, and she's going to take us through a great conversation. I do want to uplift, and this was important, is that um, as she's presenting information to us, this does not create an attorney-client relationship. She's just presenting information to us, and after she speaks, we'll be doing a Q&A that I will kind of guide us through. Ms. Nora, you have the floor.
Thank you, Professor Seals. Thank you, Kareem, for putting this together. Thank you for all of your work. I also want to shout out my little brother, Pendarvis Harshaw, who was the one who got us together. So thank you for the introduction. Again, my name is Nora Aliyami. I'm a founding attorney at Family Law Advocates Group. We're based here in Oakland, all women of color, all young women of color. So the goals for today is we want to make sure that the folks on the webinar have a general lay of the land of how family courts operate, in addition to knowing how to open a case, how to navigate a case, if there's an emergency that comes up, how to deal with that. We'll talk a little bit about substantively what the courts look for in relationship to when you file for custody and visitation, or if you're filing for child support assistance, or if you're responding to a child support request. We're going to go over basic types of cases, how you end up in court in the first place. And then, again, the emergency request, how to handle those. And then the legal theory, the things you should know, some of the buzzwords that the judges are going to be looking for when you're talking to them, either if it's in relationship to custody and visitation or child support. So, basic overview. In family court, there are several different avenues to get to where you want to go. Again, I know everyone is in a different position in terms of where your family is. You may or may not have a case open already. So if this is old news to you, I apologize, but this is important for some of the folks who may not have a case open yet. So there are several different ways that you can get into family court. So the first one is if you're filing for divorce. Pretty standard one, straightforward one. You're filing for divorce, you have kids in common, you're going to want to get your assets separated, the debt separated, and then figure out what's happening with the kids and what kind of support the kids will need. Another way that you may end up in family court is through a domestic violence restraining order. Either you are the party filing or you are the party responding. My office does represent, we have a handful of men that we represent as petitioners, as the folks going to court asking for protection from the mother of their children. So there is never, ever a reason why anyone should be putting hands on anybody. So just because you're a man, that does not mean you should be tolerating that kind of behavior or conduct. So if that's something you're going through and you want to talk about that more, please call me. in California, I know some folks are not in California, but in the state of California, we have a department, the Department of Child Support Services. And you can either engage them if you want assistance, or they may be reaching out to you if they've been tapped by the other party. We'll talk a little bit more about that, but I think the next webinar next month will have an attorney from the Department of Child Support Services. So I'm not going to spend too much time today on child support, but that's just another avenue of how you may be entered into the family court system. But the main category we're going to talk about is when you are petitioning for establishing a parental relationship. So let's say you're not married and you have a child with a woman. You may or may not have ended up on the birth certificate. So how are you going to get access to your child? How are you going to create a visitation schedule? How are you going to make sure that you have some of the rights that you're entitled to, again, within the state of California, to be an active and healthy participant in your child's life? So the petition to establish a parental relationship is one of the most common, in addition to divorce, of the ways you can end up in family court. I did provide Professor Steele and Kareem with some of the court form numbers. I don't know if anyone cares to write any of this stuff down, but if you are interested in the form numbers, family law is really form intensive in the state of California, so everything has a form you have to fill out and submit to the court. If anyone needs information about which form does what thing, I'm happy to give that information to you. Okay, so those are the ways we're going to get into court, right? You're either petitioning to be acknowledged as a parent, you're filing for divorce, there's a restraining order, or Department of Child Support Services has reached out to you, or you're reaching out to them because you're the primary parent and you need financial assistance from the other parent. One of the things I always want to say is everything that you file ever, this is a general rule, anything that you file with the court, you have to serve the other side. And this is really, really crucial, because if you don't serve the other side, the court is going to continue your hearing. So part of what the justice system requires is that supposedly both parties should have equal access to information. So let's say I go to court and I didn't receive a copy of the motion that the other side filed that's trying to smack down the motion I filed. If I don't have access to that, how am I going to defend my motion, right? So that's the same for you all. If you file a request with the court, either you're opening a case or you want to modify something that's already been ordered in your case, you want to make sure that you are serving the other side, which literally means you are serving them the documentation. And right now with COVID, there's a lot of leeway in terms of the time that you have to serve it. So between the time you file it with the court and you serve it with the other side, there's some wiggle room on that. They're also allowing more electronic service, because serving people in person is not necessarily safe right now. So whenever you're opening a case, again, we're still in the procedural part. If you ever are commencing the case from the beginning and just trying to get into family court from the beginning, that's a time where technically you're supposed to have personal service. You're supposed to have a third party, so not you, a third party who's over the age of 18, literally physically hand the other party the documents. There's generally some complications, because if the person realizes they're being served, they don't want to take it and whatever. But if you have a third party not involved with the case over the age of 18, attempting to serve this other party who is also over 18, there are ways to get around if they refuse service. But again, that's a longer story for another day. But service of process, really, really important. Make sure everything you file gets served on the other side as timely as possible. After that process happens, there's a form you have to complete, or the server has to sign off on, that indicates who was served, what they were served with, where they were served, the time they were served, and you certify under penalty of perjury that this actually happened. Family court is one of those places where there's a lot of emotions going on, and they say that family court is the place where good people are on their worst behavior, as opposed to criminal court, where people are on their best behavior. So in family court, there's a lot of shenanigans going on, because adults can be really petty. So you want to make sure that you're doing everything the right way. And that includes filing what's called this proof of service form with the court after the other side has been served with whatever documents you filed. Depending on how you're serving it, there are different variations of the form. So some may say proof of service for personal service, or one may say proof of service for mailing service. Make sure you have the right form. It's important. Get it filed as soon as possible, because if you go to court, the court's going to say, I don't see a valid proof of service on file. They may kick the can down the road. So yes, Professor Seals.
Really quick, to your point around, it being like form heavy, does the forms change based on the county?
Absolutely, really good question. And same with Department of Child Support Services in the state of California. Every county has their own rules. So I'm speaking generally to California because these rules are standard, but you are absolutely right, and I'm glad you brought that point, is depending on which county you're in, we'll talk a little bit more about ex partes in a moment, but there are sometimes some local forms that are specific to the county. So the general forms are the ones you can find on there's a state of California's website, the court website that has all the standard forms, but then your individual county will have a family law section, and in there you will find the forms which include the local forms for that particular county. And sometimes that's a drag because you're in one county and you check your local rules, but if your case is in the other county, you have to look at their local rules, right? So that's really good point. I appreciate you bringing that up. So make sure you're paying attention not only to the standard forms that are from the state, but also any local forms that are necessary to go along with your particular filings, which is a perfect segue because one of the times you always will have a local form is if you're serving an emergency request of the court. Because what happens is they're called ex parte. And what that means is that you are submitting your request to the court by yourself, ex parte, like one part, it's you. You're putting your argument in front of the court. You're asking the court for what you want, and you're not giving the other side a chance to respond. Most of the time, the court will give, 90 days before they're going to see you, so you have weeks to come together with your argument and your declarations and your exhibits or all the things that you want. With ex parte is not the case. So if there is an emergency where your child is in danger, your child is facing abduction, if you have learned that there's some other violent person living with your child and your ex, these are all reasons to file for an ex parte. Ex parte requires that there is some kind of immediate, imminent harm pending. So you can't file an ex parte just because you want to increase the amount of child support you're getting or decrease the amount of child support you're getting. There has to be physical bodily injury potentially at stake. If you file something under ex parte and the court does not consider an ex parte, they're not going to be mad, but they're also going to push you to the end of the line, meaning you're going to get a court date, again, 90 days out, maybe more. So really try to be sincere when you're evaluating whether or not this is an emergency request versus whether this is something that can be heard, a little bit down the line. Ex partes, there are always local forms that you have to fill out that are specific to your particular county. And all of those forms are different. And they're specific, not just the proof of service form that you've served the other side, but a lot of times you have to give notice to the other party even before you file. Generally, the rule is you can file it and then you send it to the other party, that's fine. Ex partes are generally the opposite. You give the other side notice. Generally, it's like before 10 a.m., the day before you're going to serve it. So a full 24 hours in advance, you have to provide the other side with the documents you intend to file, including what you're asking for, what it is you're alleging. If you're including exhibits or a declaration, you have to have everything together. Send it to the other side, generally before 10 a.m., before you give it to the court the next day. And you have to fill out this special form. Again, depending on what county you're in, notice of acknowledgement of notice of ex parte, something along those lines, that you are, again, under oath, acknowledging that you have provided this information to the other side before you filed it with the court. So for example, my law partner today had to file an ex parte this morning. So she noticed it yesterday. She told opposing counsel, I'm going to file this thing tomorrow. And they had access to the documents. We filed first thing this morning. And by 3 o'clock, they were filing their response. So it can happen that quickly. Generally, if there's two attorneys, it can happen like that. For most folks who are pro per litigants, a response doesn't get in before the judge gets to see it. Ideally, the court will respond to your ex parte within 72 hours. Again, this is California. We are in COVID, so it may not be 72 hours, but that's the goal, is that you will have temporary orders, which means the judge will have reviewed your request and made orders based only on the representation that you're making to the court, which generally is against what courts are supposed to do. But again, in cases of emergency, if a child's in danger of physical harm, they're going to make a decision right away. So for example, the case from this morning, which I think illuminates what an emergency is, our client, who's the mom, was in a really bad motorcycle accident. I'm talking about like she broke 2 legs and 5 ribs, and like she's in a full body cast in the hospital, right? Her ex is a child abuser and a drug addict. And he has a restraining order against him. And there's a specific exception for him to have supervised visitations with the child because, you know, it's potentially the child's in danger. So there has to be a third party there to supervise. Well, what happened was the third party supervisor, which is grandma in that case, left town this morning because one of her other children went into labor. So she skipped town to go be with her daughter who was going to have a baby. Well, what does that mean? Who's going to supervise dad's visits? Dad's attorney is saying there's not going to be a supervisor. And we're saying, yes, there needs to be a supervisor. This is a safety issue for the child. The child is a named party in a restraining order that's already been granted. So that's something that counts as an emergency. We're hoping to get something back from the court early next week that says, you know, unless there's a mutual person that the parties can agree to supervise these visits, dad's not going to get visits until his mother returns from the trip she currently is on. So that's ex partes. And I know, Kareem, you've had some personal experiences with ex partes. Is there anything you want to chime in and add to what you've learned through your time?
Well, for me personally, the ex parte worked very well because I was in a situation where someone had filed a false child support claim when my son my son was currently with me full time, and the child support claim was that I had never ever been involved in my son's life, and he was like 14 at the time, and so it was just the complete opposite of what was the case. And so after months of them garnishing my wages, finally somebody at the San Francisco child support office told me, hey, file an ex parte hearing. And I filed it, and they immediately gave me a court date, and then they figured out that she was lying, and it got figured out. So in my case, it worked. I don't know if I ever said there was any harm or anything like that. I just told them, hey, I have my son full time, and I'm not going to be able to feed him if you keep taking this money from me, basically. And when I finally, I guess I talked to the right person after a couple months, and they told me about the ex partes. But it wasn't readily available. Yeah, they didn't make it readily available, like information at all.
Yeah, unfortunately, I'm not all that surprised. But again, that's why we're here. So hopefully some of you other folks won't get stuck in that situation. But so yes, ex parte, generally there's some kind of imminent harm that's going to happen. And in your case, Kareem, it makes sense because if your check is getting garnished and that's how your child eats, that's an important thing. So yeah, generally the types of things that people file ex parte requests for are relationship to domestic violence, child abuse, parental abduction, or refusal to comply with orders that are already existing. That's exactly the case that I had, was that dad thinks he's going to have visitation without supervision just because mom's in the hospital and is kind of stuck there. Yes, so you want to make sure you're checking the local rules in your county about how much advance notice you have to give before you can file. And then there's a specific form for your county that you have to fill out acknowledging that you have gave them advance notice and that you have served them within a certain amount of time. And that's true even if you're up against, if your partner is unrepresented, you still have to do this really specific set of steps and guidelines in order to be successful on an ex parte. Okay, we have about 20 minutes. So we are going to get into the meat of the conversation, which is, what is the court looking for? What is it that you need to try to explain or convey to get you where you want to be? And again, this is in relationship to child support, custody and visitation, domestic violence restraining orders. How do we get you where you need to go? So let's start with legal versus physical custody. There's two types of custody, right? If you don't know, now you know. There's two types of custody. People just say custody in general. There's actually very two specific types of custody. Legal, and that's who gets to make decisions for the child, who's making decisions. You know, in California, getting vaccinated is like this whole thing right now. So there's some parents that want their kids vaccinated and some kids don't. Well, whoever has legal custody gets to make that decision. And there is an opportunity for joint legal custody. So it's not necessarily one parent or the other, but the types of decisions that are made over the child, whether it's health, where they're going to go to school, what kind of extracurricular activities they're in, anything that you're signing off for your child to participate in something, that's legal custody. So again, it can be sole, where one parent has all the rights to make those decisions, or it can be joint, where the parties are supposed to meet and confer and discuss with each other and make a mutual agreement. That can happen for a lot of parents, and for a lot of parents, it gets sticky. So just keep in mind, if and when you're in court and you're asking for custody, if it's something in relationship to a decision that's being made for the benefit of your child, that's on the legal custody side. The other part is physical custody. And that's, I think, what most people generally think of when we throw the term custody around, is where is the child physically on any given day, on any given hour? Where is the kid? Physically, where is the kid? Whose custody is the child in? So this is where parents are trying to come up with the schedule. Like, okay, I'm going to have my child Monday through Thursday, and then the other party has the child Friday through Sunday, whatever the schedule may be. So physical custody is something that changes very, very frequently. If you have a young child in particular, if they're not in school yet, better believe when school starts, there's going to be a change in custody and the visitation schedule. Two types of custody: physical custody, legal custody. Legal custody, decision-making, school, education, health-related decisions. It can be one party has the power, sole legal custody, or joint legal custody, where the parents are supposed to work together to make decisions. I had said that in California, whether or not a child should get vaccinated has become a big issue, because I'm not going to weigh in on that personally. But legal custody. Then there's physical custody, and that's what I think most people think about, which is the visitation schedule, where the child is physically on any given day at any given time. So the example I gave was, if I have my child Monday through Thursday, and then the other parent has the child Friday through Sunday. That's an example of a visitation schedule, or the physical custody arrangement. I was saying that if your child is young, you should just know that that will be going through modifications throughout the course of their life. So when they enter elementary school, they'll probably be on a particular schedule. Once they get to middle school, they're going to start, playing more sports after school. God willing, Mother Nature allows us to do that. High school, same thing. They're going to join debate or gymnastics or whatever, piano, and you will probably have to revise the schedule then. So just know that physical custody in particular is a very fluid concept that changes over time as your child ages through the system. So just know that that will be an evolving process over time, especially if your children are young. The more you can work with the other party, the more that both parents can make agreements about the activities they want their kids doing, what kind of, healthcare services they should be getting, if the child needs to be in some kind of therapy to support them while their parents are going through whatever separation stuff they're going through. That's also really important. So the things you want to make sure you talk about when you're with the judge or in your papers that you're getting ready to file with the judge. The court is always going to look at what is in the child's best interest. And the way that they assess that is looking at the health, safety, and welfare of the child. So it's not supposed to be who has more money or, who has a nicer home or anything like that. It's supposed to be health, safety, and welfare. And both parents should be able to provide that for their child. Again, ideally, parents will share joint custody, both legal and physical. But there's sometimes, one party is just not able to do that. I mentioned earlier, we have a case where opposing party struggles with an addiction to heroin and has a domestic violence restraining order against him that includes the child and the mom. So there are definitely certain times where it's not a good idea for one parent to have unsupervised physical time with a child or legal decision-making processes just because of life. They have things happening in their own life. So that's legal and physical custody. Did any questions? Am I going too fast? I'm just looking at the time. I want to get through everything. But if anyone has questions, Professor Seals, I know you'll interrupt me as needed. That's where we are. Best interest of the child, health, safety, and welfare. Now, in relationship to visitation schedules and physical custody specifically, what the court is going to look at, assuming there's no issues of drug abuse, domestic violence, child abuse, those sorts of things, this California standard is frequent and continuous contact for both parents. The state of California believes a child should be close to and engaged with both their parents as much as possible. So the standard that they use, and it's a legal standard, frequent and continuous contact. So if you're a parent who's only seeing your child one afternoon on a Sunday every week, that's not frequent and continuous contact. And if you'd like more time with your child, that's something you should ask the court for. If you don't have a case, you either get in through, a parentage action, or if this is someone who, you may be divorcing from and they're just withholding the child wrongfully, you'll file a petition to dissolve the marriage. So, if you have a case already open, again, in California, the form you need to file is what's called a request for order. They used to be called orders to show cause, but they're now request for orders. It's one of the forms. And it has all these little boxes on the top, and you check the boxes for whatever you're asking the court for. So it'll say child custody or visitation schedule or domestic violence or attorney's fees, which we won't get to today, but that's an important one for one day. And so you just check the little box, and then you fill out the corresponding section with the request that you're making to modify. So frequent and continuous contact. And again, assuming that there's no issues of drug addiction or abuse, physical abuse, that's a standard, frequent and continuous contact. Okay, let's start with legal versus physical custody. There's two types of custody, right? If you don't know, now you know. There's two types of custody. People just say custody in general. There's actually two specific types of custody. Legal, and that's who gets to make decisions for the child, who's making decisions. In California, getting vaccinated is like this whole thing right now. So there's some parents that want their kids vaccinated and some kids don't. Well, whoever has legal custody gets to make that decision. And there is an opportunity for joint legal custody. So it's not necessarily one parent or the other, but the types of decisions that are made over the child, whether it's health, where they're going to go to school, what kind of extracurricular activities they're in, anything that you're signing off for your child to participate in something, that's legal custody. So again, it can be sole, where one parent has all the rights to make those decisions, or it can be joint, where the parties are supposed to meet and confer and discuss with each other and make a mutual agreement. That can happen for a lot of parents, and for a lot of parents, it gets sticky. So just keep in mind, if and when you're in court and you're asking for custody, if it's something in relationship to a decision that's being made for the benefit of your child, that's on the legal custody side. The other part is physical custody. And that's, I think, what most people generally think of when we throw the term custody around is where is the child physically on any given day, on any given hour? Where is the kid? Physically, where is the kid? Whose custody is the child in? So this is where parents are trying to come up with the schedule. Like, okay, I'm going to have my child Monday through Thursday, and then the other party has the child Friday through Sunday, whatever the schedule may be. So physical custody is something that changes very, very frequently. If you have a young child in particular, if they're not in school yet, better believe when school starts, there's going to be a change in custody and the visitation schedule. Two types of custody: physical custody, legal custody. Legal custody, decision-making, school, education, health-related decisions. It can be one party has the power, sole legal custody, or joint legal custody, where the parents are supposed to work together to make decisions. I had said that in California, whether or not a child should get vaccinated has become a big issue because okay, I mean, I'm not going to weigh in on that personally. But legal custody, then there's physical custody. And that's what I think most people think about, which is the visitation schedule, where the child is physically on any given day at any given time. So the example I gave was if I have my child Monday through Thursday, and then the other parent has the child Friday through Sunday. That's an example of a visitation schedule or the physical custody arrangement. I was saying that if your child is young, you should just know that that will be going through modifications throughout the course of their life. So when they enter elementary school, they'll probably be on a particular schedule. Once they get to middle school, they're going to start, playing more sports after school. God willing, Mother Nature allows us to do that. High school, same thing. They're going to join debate or gymnastics or whatever, piano, and you will probably have to revise the schedule then. So just know that physical custody in particular is a very fluid concept that changes over time as your child ages through the system. So just know that that will be an evolving process over time, especially if your children are young. The more you can work with the other party, the more that both parents can make agreements about the activities they want their kids doing, what kind of, healthcare services they should be getting if the child needs to be in some kind of therapy to support them while their parents are going through whatever situation stuff they're going through. That's also really important. So the things you want to make sure you talk about when you're with the judge or in your papers that you're getting ready to file with the judge. The court is always going to look at what is in the child's best interest. And the way that they assess that is looking at the health, safety, and welfare of the child. So it's not supposed to be who has more money or, who has a nicer home or anything like that. It's supposed to be health, safety, and welfare. And both parents should be able to provide that for their child. Again, ideally, parents will share joint custody, both legal and physical. But there's sometimes, one party is just not able to do that. I mentioned earlier, we have a case where opposing party struggles with an addiction to heroin and has a domestic violence restraining order against him that includes the child and the mom. So there are definitely certain times where it's not a good idea for one parent to have unsupervised physical time with a child or legal decision-making processes just because of life. They have things happening in their own life. So that's legal and physical custody. Did any questions? Am I going too fast? I'm just looking at the time. I want to get through everything. But if anyone has questions, Professor Seals, I know you'll interrupt me as needed. That's where we are. Best interest of the child, health, safety, and welfare. Now, in relationship to visitation schedules and physical custody specifically, what the court is going to look at, assuming there's no issues of drug abuse, domestic violence, child abuse, those sorts of things, this California standard is frequent and continuous contact for both parents. The state of California believes a child should be close to and engaged with both their parents as much as possible. So the standard that they use, and it's a legal standard, frequent and continuous contact. So if you're a parent who's only seeing your child one afternoon on a Sunday every week, that's not frequent and continuous contact. And if you'd like more time with your child, that's something you should ask the court for. If you don't have a case, you either get in through, a parentage action, or if this is someone who, you may be divorcing from and they're just withholding the child wrongfully, you'll file a petition to dissolve the marriage. So, if you have a case already open, again, in California, the form you need to file is what's called a request for order. They used to be called orders to show cause, but they're now request for orders. It's one of the forms, and it has all these little boxes on the top, and you check the boxes for whatever you're asking the court for. So it'll say child custody or visitation schedule or domestic violence or attorney's fees, which we won't get to today, but that's an important one for one day. And so you just check the little box, and then you fill out the corresponding section with the request that you're making to modify. So frequent and continuous contact. And again, assuming that there's no issues of drug addiction or abuse, physical abuse, that's the standard, frequent and continuous contact. Decided upon. Once they've made a decision for you one time, unless you can show that they are biased against you and prove it, you're pretty much stuck. However, in California, they do rotate judges about every 2 years. You should also know that for whatever reason, family court is one of the first stops that judges have in their career. So some judges, that may be their very first assignment is they're doing family law. They've never done traffic, they've never done misdemeanors, they've never done anything. And they're making decisions for families, which to me seems backwards, but hey, people value money over other things, which I think is silly. But yeah, so 176 motions, hard to push through if you've already made an appearance. But that is something you can look into. This is also a good time to plug the self-help centers. Most of the counties in the Bay Area have self-help centers that are somewhat functional right now while we're still shut down, but they can direct you to all the forms that you need to fill out. And sometimes, I don't know how they're doing it these days, but it used to be you could take your filled out forms into the center and an attorney or a law student would look over it for you and make sure that everything makes sense and everything's there. So if you are embarking on a new endeavor and you want someone to look over it, reach out to the family self-help center in your county. And then the state has a family court facilitator's office, which may also have information for you. Okay, so I know that there is a presenter who is an attorney for the Department of Child Support Services who's going to come and do this next series. So I don't want to step on their toes. I know far more about this than I do. But the legal concepts that you should consider when it comes to child support, whether you are the person applying for assistance or you are the person having their wages garnished, California public policy states that both parents should be or are equally responsible for the financial care of a minor. So that doesn't necessarily mean each parent, is giving the same amount of money each month. But what it means is that both parents should be contributing. And the way that they determine how much each parent contributes depends on two factors. First one is that visitation schedule we talked about. And going back to my example, I have my child Monday through Thursday. Other parent has child Friday through Sunday. Well, you do the math. So you would actually look at how many hours each parent has the child in a given week or in a given month and see what the percentage is, the ratio of the timeshare of physical custody where the child is at any given time. So just hypothetically, let's say I have my child 60% of the time and other party has a child 40% of the time. They're going to use that number to plug into this fancy computer program. And that is one of the factors they use to figure out who's paying who and how much. The other factor that they look at is each party's income. So if one parent is working and the other parent is not working, well, that's going to make a huge swing on who's paying who and how much. But it's always coupled with the visitation schedule. And then there are other things that they stick into this computer program. But the two biggest factors that you should be aware of is the visitation schedule, again, the percentage ratio timeshare the child is with each parent, and then the income of each respective parent. One other plug for Department of Child Support Services is that if either parent is on any kind of a cash aid, you're getting CalFresh, CalWorks, TANF, any of those government-funded assistance programs, Department of Child Support Services will reach out and say, do you need us to get involved? We're going to get involved because someone, there's a child here and someone qualifies for financial assistance from the government. So we want to make sure that both parents are equally contributing to this child, and the burden doesn't just fall on one parent. Again, you will hear more about Department of Child Support Services soon. Okay.
Quick question on that, Nora. Can you just quickly touch on the fact that they won't go backwards in time and count for physical custody? So for instance, let's say you and your co-parent have a 60-40 split, but then like 2 weeks out of that month, you actually keep the child 60% and they keep it 40. Will they count that time? Can you just go into court and say, oh, hey, but I had my child this last week. It wasn't 60-40, it was this. Will they count that, or how does that work?
So is that part of the visitation schedule in your hypothetical, or is that just like on the fluke that happened one time?
It's on the fluke, but maybe it happens once, maybe it happens 3 times, maybe it happens, maybe it's by case situation, like every day is different. So would they give you credit if you just went in there and said, hey, I had them more time this week? How does that work?
Yeah, no. No, you don't get a bone for that, unfortunately. Which is why I really encourage my clients to follow the visitation schedule to a T, and then request to modify the visitation schedule if things continue to come up. But my brother, for example, he's divorced. He has 2 children with his ex, and she was dropping the kids off like an extra day every week. And he's like, I'm paying you this child support, but I'm taking care of the kids. That's the other thing. People have a misconception about kind of the theory of why child support happens. So the theory is you have 2 parents, the child's going back and forth between the 2 parents. If you have one parent who has 80-90% visitation schedule, on a day-to-day basis, they are providing for the financial needs of the child. They're making sure the rent is paid, electricity, water, food, shoes, clothes. Mom, I want to go to the movies. Let me get some money for the movies. Pre-COVID. Let me get some money for the movies. Whatever it is. The assumption is that the parent that has more time is cashing out more money every week, every month. So the parent who has less time needs to be giving more financially to make sure that child is taken care of. So again, my brother as an example, he was having extra time with his kids, which he loves, but at the same time, he's like, I'm paying you based on this schedule, but if the kids are with me more, why am I paying you for this? So I really encourage my clients to stick to the schedule as close as possible, unless there's some kind of an emergency. I always want people to co-parent and be able to support each other when things come up. But if you're cashing out a lot of money in child support, it's really not cool that that other parent is taking advantage of you, because you're paying the money and you're spending money because you have the kids with you more. So keep that in mind. The more time you have with your child, the less you'll pay in child support, the more time you have with them, and vice versa. If you're not seeing your kid, you're really not participating, you're probably going to end up paying more. So piggybacking off of that, there's what's called, some of you may have heard of back child support. Someone owes back child support. It's called arrears. And what that means is that some significant amount of time has passed where that parent hasn't been meeting their obligation, whether there's a support order in place or not. So we've seen cases where a kid is 5 years old and one parent hasn't been contributing, and then there's a case filed. They will argue that I should have help from all this stuff from years ago. So you want to be aware of that too. Even if you and the mother of your children are in a good place right now, just keep track. Keep track. If you're doing money transfers into her account, if you're writing checks, don't do cash, okay? Because there's no paper trail. You want to be able to show the court that you have been voluntarily, if there's not a court order, paying a certain amount of money each month to help support your child. Paper trail, always, always important. The other thing you should know is that if you're filing for child support or a modification of a pre-existing child support order, there's retroactivity, which means that the court will look back to the date of the filing and make orders based from the date of the filing. So not the day you come into court. So pre-COVID, you file a motion in the beginning of March saying, I want to modify child support. Well, that's the day that the court is going to consider whatever that potential disparity in the money is. So you file a motion March 1st, before shelter in place, before the court shut down. You don't get a hearing date until August, because that's just what's happening right now. The court will look at the time between March 1st and August to see what you've paid. And if there's some discrepancy in what the court orders in August, they will order this offset or reimbursement of arrears. Does that make sense? Never cash. Don't do it. Don't do it. Even like Cash App or Venmo is better. You have to have some kind of a record, right? Okay, so great. That gets us through the child support section. So far we've talked a little bit about procedures, how you get into court, whether it's through parentage action, whether it's through a dissolution of a marriage, restraining order requests, Department of Child Support Services. You have to have one of these avenues to get a case going. If you don't have a case going, you need to start by getting one of these cases open, filing a petition under one of these kind of major avenues. Once that happens, you start filing these forms, the request for order forms, the FL 300 in California, and you just check the box. You say, I'm trying to modify custody and visitation, or I want to modify child support or spousal support. And that's how you get your motion in front of the judge, is the FL 300 form. We talked briefly about ex partes. It's also worth saying that the FL 300 form will also accompany the ex parte emergency forms that we talked briefly about, because every county is a little different. So on that FL 300 form, there's also a box on the top. It says modify or ex parte. So they're assuming you're doing one or the other. If you're just now filing your petition to get in the court, include a request for order when you first file, because otherwise you're opening a case, but there's nothing pending. So that FL 300 is a form you should get really familiar with, because you're going to need it. We talked about, a little bit about emergency requests, how they can be helpful. We talked about serving the other side. Everything you file with the court needs to be served on the other side, timely, preferably. And then the general concepts that come up in family court. Child custody, there are two types of custody, physical and legal. The court can order sole to one parent or joint to both parents. The visitation schedule falls under the physical custody component, and that's the timeshare. Where is the kid physically at any given time? And then based on that timeshare, that goes into what calculates the child support award and how much who's paying whom at any given time. Yeah, and the visitation schedule, both parents are entitled to frequent and continuous contact. That's important if you have one parent that's just kind of gatekeeping and withholding access. That's a legal term of art, frequent and continuous contact. It's in the statute. Talks about family court services. There is a difference between recommending and non-recommending. Either way, you're going to meet with a staff person of the court who's a counselor. They will talk to both parties, take an account of what both parties are saying, maybe come up with a recommendation if you're in a recommending county. If you're not in a recommending county, you may not even see what they write at all. We talked about briefly asking for a written statement of decision. You can't ask at the end of your hearing. You have to ask at the beginning of your hearing. And what that does, in my experience, is that it makes the judge has to get held accountable, right? So if you're asking for a written statement of decision, they have to go through their analysis and apply the facts of your case to the existing law that sets precedent or governs that particular subject. So again, if you don't trust your judge and you can't get rid of them, always ask for a written statement of decision, knowing the caveat that if this is a continuing issue or a motion that is going to be continued, they don't have to write one if it's something that's being continued. Judgments is a whole nother thing, but we didn't get there. That's okay, that's down the line. Family court services, talked about child support. Each parent's equally responsible. They have this fancy schmancy software calculator. They plug in all kinds of numbers. The two most important ones are the percentage of timeshare, where the child is physically, and then the income of both parties. We talked about retroactivity and arrears, back child support. If you need to make a change, file something as soon as possible, because that flags the date in the system that any modifications that are made will go back to the date of your filing. Yeah, utilizing self-help services and the family law facilitator's office in your particular county. I know we're all coming from somewhere else, but I'm hoping wherever you are, there are some free legal services.